Mr. Sibal, Mr. Kamath, Mr. Paul, Mr. Jetmani, Mr. Maninder Singh, and the solicitor. We are very honored to have in our midst Chief Justice Martha Koome, the Chief Justice of the Supreme Court of Kenya. And not the least of her achievements is that she is the first woman Chief Justice of Kenya, but a judge of very high erudition who has written extensively, including on issues pertaining to constitutional law in India. Chief Justice Martha Koome wrote a judgment recently on the extent to which the basic structure doctrine would apply in Kenya when almost 73 articles of the Constitution were sought to be amended. Then she's also been a part of the bench recently on the recognition of LGBTQ rights in Kenya. Before she became a judge of the Supreme Court, she was a very active member of the bar, has had wide experience in society. So we are very privileged to have the Chief Justice of Kenya in our midst this afternoon. So we were late by 10 minutes because I was trying to give her a brief wrap-up of what is being argued here. And since the matter is still awaiting judgment, we have been as objective as possible in chambers in trying to tell the learned judge about how the matter arose and what was the issues here. So we'll, yes.
Honored. We're all honored.
On behalf of the bar, we welcome the Chief Justice.
Here with us. The other colleagues of Chief Justice Martha Koome are here, the Deputy Chief Justice. So we welcome all of you as well in our midst, and hope that you will keep on visiting our court and country more often.
Thank you.
Yes, Mr. Jetman.
Well, I was reading paragraph 237.
Instead of reading the 17-page note, why don't you formulate what the essential points are?
Yes.
So that then we can, we know where you stand.
But at the end of each, I was going to make my proposition. At the end of each. So I just finished this.
Why don't you formulate what you have to say so that we'll read the note. There's no difficulty about it.
May I just finish reading 237 and 238, or it's not? Your lordships are familiar with it.
We've already read that judgment.
Continue from your note.
I'll read.
Or if you can formulate what your submissions are, isn't that may be better. If you can.
Well, as I said, my submission on this aspect of the matter, first, of course, it's not necessary to go into any revisit of the judgment in Nabam Rabia. But the lordships do want to revisit it. It should be for reaffirming the view enunciated, in particular by the decision of Justice Mishra, which is that he's disabled. A speaker or a deputy speaker is disabled for his functions as a speaker at the time of a notice to remove him, and not at a subsequent stage when that notice is under consideration.
Yes.
Now, so that view, my lord, sir, I'm now reading page 6 of my note, is fortified by the following submissions. The fact that a prior notice of 14 days is to be given, has your lordship's got that, my lord? I'm at page 6 of my note. Presents every opportunity to those aggrieved by the said notice to thwart the intention of the notice. A speaker or a deputy speaker whose removal is intended will be tempted to take all steps available to him to dissuade or prevent the mover of the motion from proceeding with it further in that 14-day period. So that 14-day period provides him an opportunity which not only is capable of being misused, it had been misused, and I showed that particularly with reference to the facts of the instant case. And that's my second proposition, that subsequent events revealing gross misconduct and partisanship on the part of the deputy speaker, as more particularly set out here, and I'll come to those, during the 14-day notice period, vindicate the view in Nabam Rabia regarding the period when the deputy speaker's or speaker disability under Article 181 commences. Then third, Article 181 deals with a situation where the resolution for the removal of the speaker is under consideration and prescribes the restrictions on the speaker or deputy speaker, that at a sitting, that article is concerned with a sitting of the Legislative Assembly. Please note that, my lord.
Yes.
At a sitting of the Legislative Assembly, when such resolution is under consideration, then the deputy speaker or the speaker, as the case may be, shall exercise all the powers available to a member of the Legislative Assembly, but not those that pertain to the office of speaker stroke deputy speaker. Now, my lord, this is logical. I'm sorry.
Yes.
This is logical, as the notice for removal is from the office of speaker, deputy speaker, and not as a member of the Legislative Assembly. While Article 181 uses the word any resolution and not notice of intention for removal of the speaker, that is because while consideration of the resolution has to be during the sitting of the Assembly, or it can only be when the House is in session, a notice of intention can be given even when the Assembly is not sitting. So Article 181 itself does not prohibit a construction that a deputy speaker cannot act as such deputy speaker from the time a 179C notice is moved. 181 deals with a sitting for consideration of the Legislative Assembly. And below the rules between 179C and 181, that is notice given and then 181 consideration of the notice, there is a vacuum. That vacuum is filled up by Rule 11. The House itself has made rules as to what will happen in that interregnum. But if you just want, I'll read it very quickly. Rule 11.
That's all right.
Not
We've seen the rule.
We have seen Rule 11.
So now in short, but not he has to give a notice 14 days period, and then as soon as may be. But the House rules make it almost impossible for there to be any serious delay in the matter pertaining to disposal of this issue of his removal. Because it's only that 14-day period. Immediately after the 14-day period, he has to refer it to the House. And then, so basically it's 14 days. And
So according to the prohibition, the period when the speaker is barred from considering a petition for disqualification commences the moment a notice is given.
yes.
Commences the moment a notice is given.
And any misuse is circumscribed by the rules of the House, which say immediately after the 14 days almost, you must put it up to the House. If you get 29 members, it will then be considered. You don't get 29 members after 14 days, the issue is dead and then.
All right. What is the next point now?
Then the provisions of Article 181 of the Constitution are based upon the rule against one being a judge in one's own cause. In other words, the nemo judex in cause sua rule. There is no reason why this rule should be restricted to the case of consideration of resolution, but not at the stage of notice, when a speaker who continues to function as a speaker can use his powers as a speaker to alter the constituency that will decide on his removal. So he can gerrymander the constituency that decides on whether he should, if he's allowed to remove them. And that's the whole purpose of. Now, the Lordship will kindly have, what is it that is prevented by 179 or 181? It is that the speaker cannot preside. He cannot preside over the House. That word is important. By presiding over the House, he gets several powers, which can, and his powers, at least under our Constitution, are almost paramount. They're unchecked. His is the last word. Regarding procedure in the House and decisions taken, his is the final word. There's no check on it within the House. It's only governed by the rules. That's it. Now, Your Lordship, we quickly see two rules which have not been pointed out so far. Rules 53 and 58 of the Maharashtra Assembly Rules, PDF 34 and compilation 3C.
Is the PDF page?
PDF 34. 34. I know that it's the possible abuse of his power to preside that has warranted 181, that has brought 181 into existence. Now, under Rule 53, for instance, I'm just giving an example as to what he can do to scuttle the constituency, to scuttle the number of members who might vote against him. The Speaker may direct any member who refuses to obey his decision or whose conduct is in his opinion grossly disorderly to withdraw immediately from the assembly, and any member so ordered to withdraw shall do so forthwith and shall absent himself during the remainder of the day's meeting. Now, this is a part of suspension, essentially. So on that day, on a particular day when he's being voted, he can resort to this power and there's no check. That is why his powers of presiding over the House are suspended when his motion is under consideration for his removal. Now, Lord, by a parity of reasoning, what applies here should equally apply to that 14-day period, because he can scuttle members during that time. In fact, as happened in this case, he can totally ignore the notice at all. A speaker prone to doing that, as he has done in this case, can well not scuttle the entire removal procedure. And I'll briefly remind your Lordship at the appropriate time as to what he did in this case. So, for logical reasons, there is no ground to distinguish between the 181 stage and the 179 stage. The nemo judex rule will and must apply at both stages. Otherwise, you check him at the 179 stage, but he can scuttle the entire removal motion at the 14-day period 179 stage. '58 is an all. 58 of the rules is his residual power. He is the final residuary authority of all power in the House. All matters not specifically provided for in these rules and all questions relating to the detailed working of these rules shall be regulated in such manner as the Speaker may from time to time direct. So anything that's not provided for in the rules is at his sole discretion. That's how powerful he is. Now, my lords, that's the proposition. The proposition is that the judgment in Nabam Rabia must be reaffirmed and put on stronger ground for the reasons I respectfully submit I have advanced in this note. There may be something to say about the then member's part, but there are stronger grounds. This judgment can be put, this authority can be put on stronger grounds if your lordships are to revisit the judgment. Now, I come to the next factual conspectus, and that is now on 22nd June. On 22nd June 2022, Sunil Prabhu, acting as Chief Whip of the SHIVSENA Legislature Party, issued a notice calling all members of the SSLP to attend a meeting to be held at the CM's residence on the very same day at 5 p.m., failing which consequential action against the delinquent MLAs under the relevant provisions of the Constitution of India would be taken recourse to. The said letter was replied by Shri Eknath Shinde on the same day, disputing the authority of Sunil Prabhu and further stating that Bharat Gogwavle had been appointed the Chief Whip of the SSLP. It was also said in the same letter that the notice was invalid, PDF page 51. In view of non-attendance by Shinde and other MLAs of the Shiv Sena, an illegal resolution was passed. Now, please note, they didn't attend that meeting. For that very elementary ground, a notice was then issued. A resolution was passed by 14 MLAs of the UT faction to take disciplinary action as provided under. So this is the starting point. Disciplinary action under 10th schedule. For what? For not attending the meeting. Now, my lord, the contention of the petitioner is that the notices issued on 21st and 22nd were validly issued and were binding on all members of the Legislative Assembly. Our contention that the two resolutions of 21st and 22nd were illegal for the following reasons. Prabhu had been removed as the party whip by 34 MLAs of the Eknath Shinde group on 21st June itself. After he had been removed, he issued that notice or notices. The notices were therefore without jurisdiction. Now, very important. Moreover, it is well settled that a party whip can only be issued for actions on the floor of the assembly and not outside the house. The party whips of 21st and 22nd June were misconceived and illegal insofar as their content was concerned. Now, my lord, over here, there's a new document which is not before your lordship, but we have filed it just now regarding the Legislative Assembly debates, the parliamentary debates pertaining to the 52nd Amendment in 1985. I'll just read the speech of one member. What is the reference? It's the last document on record.
Last document means where? Where is it?
Is it scanned?
Well, we just filed it in the lunch break. I'm sorry, my lord. We just discovered this document.
All right, you can just refer to it.
Where is it? Now, my lord, this is the speech. What happened, my lord? And there's another provision.
Who is the speech by?
By Sharad Dighe, one of the members of parliament in the Lok Sabha, who said this. Now, what happened was, originally, the bill had three provisions under 2. 2A as it presently stands, 2B as it presently stands, and 21C. There was a third provision. That third provision permitted disqualification for activities outside the house. Now, I haven't got the exact provision, but I'll get it by this evening and tender it. Because we only just discovered this. The third one was removed. By debate, it was deleted. 21C was deleted, and your lordship will just see one. It's at PDF 38, your lordship can just note. Where is the marked part? This is what he says. This is what Mr. Dighe says in the parliamentary debates of 1985. I'm reading from the parliamentary debates. Now there have been several clauses in this bill, and I am happy that the law minister has also announced that 2 of the clauses are to be amended. As far as clause 2, subclause 1, paragraph C is concerned, that has to be deleted, and paragraph B has to be amended suitably. It was very much necessary to delete paragraph C because if a member has to be expelled from a political party in accordance with the procedure for anything done outside the house, it would have created several practical problems, and it would have given a handle specially to the bosses of smaller parties where this paragraph would have created some difficulties. Therefore, the main principle of this disqualification is that for something which a member does in this house, in the presence of this house, such as voting against the party or abstaining from voting against the direction of the party. Now, this is something which is proved beyond doubt. No other inquiry is necessary by any other committee or anybody else. So it is very clear that any act done by a member in the presence of a presiding officer, namely voting or abstaining from voting, would entail him to this disqualification. So there is no injustice, no chance of any injustice being done, nor is there scope for any doubt whether he has committed that act or not. Therefore, from that point of view, acts done outside the house have been deleted or are proposed to be deleted now because there would have been the question of proving them. Some doubt may arise, and there will be the question of giving a hearing to the member, and also the rules of natural justice would have to be followed. So the whip squarely applies for disobedience on the floor of the house. It doesn't apply to acts outside the House. This is not to say that 21A is out. 21A is still there.
But isn't that on the merits of the disqualification
exactly-
petition?
Where does
Yes, that's
add up
This
to?
wouldn't really help you
But
at
right
all.
now, I'm not on the.
Because therefore your contention would be that, well, the disqualification was not attracted. But even assuming that is so, that's the jurisdiction of the speaker.
Yes, your lordship is right.
It's exclusively
That-
within his
so therefore, what is being done in this case, or proposed to be done, because it was never acted upon, what was proposed to be done by the letter seeking my disqualification was to bring in through the back door a 21A situation, which is because this was an act outside the House, which is prohibited. 21C, legislative intent was to take out 21C.
Then, Mr. Jetmalani, in that sense, Mr. Sibbal's argument was that this was a per se disqualification. You're now dealing with a per se disqualification on merits. Your argument all along has been, the argument of your side has been, don't go into the per se disqualification argument at all because it lies within the domain of the speaker to decide. Now you're really by going into the merits.
Actually, this is purely.
No, my lord, at the moment, I'm not
merits.
at this moment, I'm not on the disqualification petition, which I will
And
come
then
to.
you are inviting us to go into Mr. Sibbal's argument as to whether there's a per se disqualification.
But I'm not.
He's right, he may be right on that.
But at the moment, I'm not on the disqualification petition. I am on the two letters which are sent to me. Please see that.
Oh, why should we go into the merits of the disqualification at all? Because once you say
All right.
that disqualification lies exclusively within the domain of the speaker, then perhaps then it would be internally inconsistent for you to argue that, well, there was no disqualification.
There were two grounds in the disqualification petition, and they were both based on this letter.
But you can very well stop at the place where you can very well say that as it is the prerogative of the speaker to consider. We will. Why should we? That
It
is
can
not
stop.
10, Mister.
It can stop there. Your lordship is absolutely.
Don't try to justify whether there was a disqualification or not.
I agree. I don't need to go that far, but since those two letters were the very grounds of my disqualification,
Okay, Mr. Bijay.
All right. What is the next point now, Mr.
now the next one.
Mr. Jetmalani, what was the page number since we've got that downloaded, airdropped to us? Just tell us the page.
I'm saying Nabam should be
No.
reaffirmed.
The speech.
On last debate.
The debate that you refer to of 85, it's been airdropped to us just now. Just indicate the page, please, for us.
Yes.
What page?
It's been said
Page 38. Page 38.
38, all right.
Now the second. Now don't bring these serious matters.
What's the next point?
The next point is that the fact of 34 MLAs being part of the real recognized SHIVSENA, and this is more substantial, was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date, which clearly spelled out
Mr.
that
which part?
I'm reading now at P11.
P11.
P11 is written.
What happens?
Page 11.
Yes. The second point.
All right.
That the fact of respondent 34 MLAs being part of the real recognized SHIVSENA party was disclosed to the Deputy Speaker in the said MLA's letter on 21st June, wherein they had enclosed the resolution of the same date, which clearly spelled out that they were the real SHIVSENA party. The Deputy Speaker ought inter alia to have desisted from proceeding any further with the disqualification petitions, as it should have been obvious to him that there being now two groups, each claiming to be the recognized SHIVSENA, the dispute on the issue was a matter which was squarely within the jurisdiction of the Election Commission under Clause 15 of the Symbols Order. So, my lord, the proposition here is that once the claim is made that we are the real SHIVSENA, as opposed to a second group, that we are, in other words, that we have both legislative and organizational majority or heft, the Speaker should desist from proceeding further with a disqualification proceeding pending an adjudication by the ECI, because the Speaker can only go into legislative matters. He cannot go into the organizational situation. In the facts of this case, I may say one more thing. In the facts of this case, all the MAs, MLAs in this case, all MLAs, this is part of the party constitution. All MLAs, all MPs of every house are ex officio members of the Pratinidhi Sabha, which is the supreme organizational body of the Shiv Sena. So even if the speaker in this case were to adopt the twin test, the second one being the organizational issue.
But Mr. Jethwani, this point Mr. Kaul has also already made, that it is not the case of your side that there was either a split or merger in the political party. The contention was that a rival faction in the Shiv Sena represented the real Shiv Sena.
Real Shiv Sena.
And this has now been found to be true and correct by the subsequent
by the ECI.
Right.
So a question was posed.
But therefore, Mr. Kaul has made that point. I don't think you need to.
So the question was posed whether what should be the conduct of the speaker when such a situation has been pointed out to him.
You are saying
not a split.
You are saying that he has no jurisdiction at all.
He has no jurisdiction. He must submit to the jurisdiction of the ECI. He should desist from pursuing the disqualification proceedings further. Now, my lord, we come to the very important aspect of this matter, which actually takes out the foundation of the applicability of Nabam Rabia. Now, on 24th June 2022, the Deputy Speaker wrote an email to the advocate for the 34 MLAs in response to their notice of 21st June under Article 179C, stating that he could not recognize the email ID from which the notice under 179C was sent. Therefore, he would take no further action until and unless the genuineness or veracity of the said signatures on the letter or the email ID is ascertained. So, in fact, he ignored Nabam Rabia, or ignored it on extremely specious, frivolous grounds, that I could not recognize it and I would wait for verification. That verification was never communicated. So where is Nabam Rabia even involved in this case? You either ignored the dictates of a constitutional bench judgment, or alternatively, you ignored it, you rejected it on the basis of extremely flimsy grounds. But in any event, you never acted upon it. That notice under 179C never ever obstructed the speaker from what he went on to do, because he contemptuously ignored it on specious grounds. And he disobeyed the then mandate. Nabam Rabia was good law and he ought to have obeyed it. So now this is the real nub of the issue, when the whole case is one of deemed disqualification. And Nabam